Good afternoon, everybody, and welcome along to the fourth in our webinar series dealing with the psychology of claims. Today, we're talking about value, cost, and damages, recognizing the differences, when to apply, and the evidential documentation required to prove the case. I'm Alex Johnson. I'm a partner at Freeths, a law firm. We're specializing in engineering and construction. Joined as usual by John Fotherby, partner from Kingsfield Academy, and we also have Wayne in the background as ever, working his magic. As I mentioned, this is the fourth in a series of 5 between now and early October. The final one is in the first week of October, and we've been looking at how to overcome the burden of delay and cost overruns in the context of the psychology of claims. Previously, 3 weeks ago, we talked about schedule delay analysis, and having spent a couple of our webinars now dealing with concepts related to time, we're focusing now on the money. It's often, and in my experience and certainly in John's experience, that a fundamental question that is applicable to any claim often gets asked way too late in the process, and that question is, what's the claim worth? Now, it sounds simple, but actually that can be a very complicated question for the reasons that we'll explain in the webinar. And I think the complexity of that question probably explains why it's often asked too late in the day. The webinar's for 1 hour as usual, and as ever, we have a load of content to get through. But if you do have any questions, please use the panel and submit those to us. And if we have time at the end, we'll try to answer those. Otherwise, if you have any questions, then just email us directly and we will be happy to respond. So by way of introduction, value, cost, and damage. These are often misunderstood concepts. So today's webinar is dealing with the topic of the recovery of money in terms of claims. We're going to put to one side extension of time claims, which are obviously all about avoiding liquidated damages. We've made the point previously that time claims and money claims are separate and must be claimed separately. So today we're looking at the separate claim of money. Money claims such as for prolongation costs, overheads and profit, and other forms of financial loss. So I'm going to go straight to John. John, what's your experience with how people deal with money claims?
I think in my experience, people treat money claims as being obvious. For example, they say, I have a loss, so somebody has to pay, and mistakenly equate assertion of that loss to proof. So they say, I believe I'm owed £1 million, therefore I must be paid £1 million. But they don't have a shred of evidence to support what they're actually seeking. And that's where I think the thing falls down immediately. And they don't link anything with cause, effect, amount, liability, etc. So they don't look at the bigger picture of what's driving that cost. I've seen on many occasions that the sort of beliefs around this remain untested, as you just mentioned, to any serious extent until we have contact with the enemy. In other words, we've actually put a claim in, or we're in arbitration or litigation, and at which point it's then too late to start rethinking. So I actually think there's a number of human elements involved in this that contribute to this perpetuation of the beliefs. I'll just mention a few of those. I think, first of all, the financial or reduced profit on a project appears to be explained and is recoverable, and therefore it's not our fault and it's the other sides. And that sort of explanation is really handy for project managers and management, because the problem's solved. It's somebody else's fault. And connected with that, giving and receiving bad news is not normally a popular pastime for project managers and management. You know, best to be avoided. They'll say, sure, there's a loss, but we'll recover it with our claim, and therefore not a problem. And we don't face up to the potential of loss at that time and what to do about it. And then there's the issue of ego. I've often heard people say, that owner drove me mad during the life of the project, and now he's going to pay. and they conjure up financial claims that they're going to get some sort of retribution for. And then we have the hardy perennial, as I see it, which is, and I've heard this so many times, we have to increase the amount of the claim because the other side's going to knock us down. And, you know, Arcadia in their report say one of the reasons for disputes is badly prepared claims, and many claims are badly prepared because the money is totally wrong, not believable. And I think we're going to come to that a little bit later on today. So there's several behavioural issues. I'm not going to go to any others. We've mentioned a few. The point is that failure to get to grips with the money issues is fundamentally about human behaviour at the end of the day, because we don't want to talk about it, because sometimes, as you said, it's too complex and it's too scary, but it's a real problem. So in my practice, and before launching a claim or getting into dispute, I think it's really important to know how much is the amount, if anything, that's really owed, who owes it and to whom, because often it's not entirely clear. Why do they owe that amount of money? And on what basis can that amount be recovered? And what evidence have you got to support it? So if you know within a reasonable degree of accuracy the amount properly owed, then that can be compared with the cost of recovery. So are we investing a little to recover a lot, or are we investing a lot to recover a little? And if it's the latter, then that's going to create all sorts of problems. But if you deal with it up front, then you know about what you're doing, you know what you're letting yourselves in for, and therefore you can plan accordingly. Otherwise, somewhere along the line, there's going to be a fairly big problem. So also, on the other side, in my experience, the amount recovered for money claims is often well below expectations and actual entitlement. And I think there are two fundamental reasons for that. The first is not enough attention is paid to the nature and quantum of the claims from the outset. So we don't actually get down to what is the real amount of money. And the second is a lack of understanding of what is actually being claimed and why and on what basis.
Yeah.
So that's my sort of experience of it, and it's been a continuing problem for a lot of years.
Yeah.
So if we're thinking about claims and the basis of claims, what are the different differences between value, cost, and damages then, Alex?
Well, we'll get into that, and I think all that was really interesting, John. But I think we'll do it slightly differently today. So what I'd like to do is we'll do a quick series of polls and see what everybody thinks, and see if, based on what John said, whether that reflects some of your own experiences and your own understanding of some of these concepts. So Wayne, if we could bring up the first poll, is there a difference between value, cost, and damages? It would be great to see what you all think. Is there no difference? Is there very little difference? Is there a big difference? Or are they just words? Do click your answers and tell us what you think, and Wayne will flash the results up to us very soon. Let's see, we've got some answers coming. That's good. Okay, there's a big difference, and nobody fell into the bear trap in the final question. Good. I think you are predicting where we're heading here, which is good. So let's go to the next poll. There is a difference. Poll number 2, is there a difference between value, cost, and damages if your claim is for extra work, i.e. change orders, or the recovery of costs? This is a simple yes or no. So tell us what you think. Whether there's a difference if the claim is for extra work or the recovery of costs. Okay, again, we've got some results coming. Yes, absolutely. That's great. 80% of you, you're heading in the right direction. So we'll do one final poll, similar question, but slightly different. Is there a difference between value, cost, and damages if your claim is for a breach of contract or a claim under the contract? So again, just select your yes or no answer if you think there's a difference between value, cost, and damages if your claim is for breach of contract or a claim under the contract. And again, let's see what you have to say. Great, let's see what the results are. Oh yeah, okay, again, we've got a good majority saying yes, slightly down from last time, so 73% of you think there is a difference. Again, there is. We've given some slightly leading questions there in the poll, but what we've been trying to demonstrate, and we'll go into each of these topic areas during the course of the webinar, is there is a substantial difference between value, cost, and damages as concepts, even though they all might seem to deal with similar sorts of things. So let's go into the concepts. They need to be thought of as separate and distinct. Value first. Typically, value relates to the assessment or the measurement of completed or varied work under a contract. And you are probably aware that there are clauses that prescribe how varied work is to be valued, for example. Clauses typically take a form which is something like, if the rates and the prices in the contract can be used to value a change order, then they should be used. So, for example, if the contract contains a rate per meter of pipe work, let's say, and the owner orders 100 more meters of pipe work than was originally in the contract, then the contractual rate can be used. So the next part of this is where the rates and the prices in the contract don't directly apply, but they can be used to value the change order because the works are substantially similar. It's almost that the rates can be applied by analogy because there's enough that's common between the rate and the rate for the new value of the varied work. And then finally, if the rates and the prices in the contract can't be used, commonly a contract will say that a fair valuation is to be made. And safe to say that there's case law on what fair valuation means that goes a long way beyond our webinar today. But that's in essence a fairly common valuation clause. The next concept is cost. So cost is the expenditure that the contractor makes to carry out and complete the works. And sometimes cost is defined in a contract. So for example, the FIDIC terms define what cost is. Generally it includes overheads, but not profit. So if we consider the FIDIC definition, this is from the Silver Book 1999 edition, cost means all expenditure reasonably incurred or to be incurred by the contractor, whether on or off the site, including overhead and similar charges, but does not include profit. I think that's a fairly useful working definition of cost. And finally, damages. Damages are financial compensation that's paid by one party to the other for a breach of the contract. And the purpose of damages under English law is to put the injured party in the position that it would have been in without the other party's breach of the contract. So the concept of damages is compensation, not punishment. Damages cannot be too remote. Now, remoteness of damage is a principle that is derived from a very famous English case that probably any law student will be able to tell you about, called Hadley and Baxendale. And we often refer to the two limbs in Hadley and Baxendale in terms of the remoteness of damage. This case said that the correct measure of damages for breach of contract is limited to direct losses, which are known as limb 1, and indirect or consequential losses, which is known as limb 2. And those phrases are probably quite familiar to any of you that regularly draft or negotiate contracts. So limb 1, direct losses, what are they? These are losses that arise directly and naturally as a result of the breach of contract. So an example may be loss of profits or other losses that directly flow from the breach. Loss of revenue could be an example. Limb 2, indirect or consequential losses. These are losses that result from special circumstances which are only recoverable if the other party knows of those circumstances. So this is loss that was within the contemplation of the parties as being the likely result of the breach of contract. So this could include, for example, if a subcontractor breaches its subcontract and causes losses to the main contractor under the main contract, those may not be too remote, but it probably relies on the subcontractor being provided with a copy of the main contract and understanding what the potential losses could be. So if you, as part of your role, regularly seek exclusions of indirect or consequential losses in your contracts, then typically you're trying to exclude Limb 2 type losses. A note about that, loss of profits can be direct loss and therefore part of Limb 1. I think I've encountered sometimes a perception that if a party is excluding indirect and consequential loss, then it has automatically excluded loss of profits. That's not correct. So you have to be careful if you want to exclude loss of profits that you specifically do that. And finally, I think for our purposes today, it's important to distinguish between claims that are made for breach of contract and claims that are made under the contract. This was our final poll question. Breach of contract results in damages, and that's a common law remedy. The recovery is compensatory and it is subject to any limitations or exclusions of liability in the contract, whereas claims under the contract are different. So as we know, most sophisticated engineering construction contracts will give the contractor certain rights to additional payment in particular circumstances, and those circumstances might otherwise be a breach of contract by the employer, for example. So an act of prevention is a breach of contract, but it also generally leads to an entitlement to additional cost. Now, these rights, these contractual rights, are usually in addition to any common law remedy for damages for breach of contract. And the contract will probably define the scope of any additional payment. So the FIDIC contract, for example, provides that the contractor may receive costs and profit only in certain circumstances. So I think it's very important that we don't confuse value, cost, and damages. And as John mentioned to begin with, the value of the claim needs to be assessed as early as possible because it affects many things, including the strategy for dealing with the claim, whether to commence proceedings at all, whether you should be aiming towards a commercial settlement, whether what you are seeking to achieve is disproportionate to the amount of money that will be required to achieve it. There are many things that need to be informed by how much the claim is worth. So I think most importantly, in starting to look at losses in more detail, it's important that losses go into the right buckets. And we'll be talking about buckets quite a bit from now on. This is get the claim right and don't make the wrong claim. So which buckets of loss you choose to put the losses in is very important. And remember the Arcadis report that John mentioned found that the reason claims fail, and the number one reason, is poorly drafted or incomplete and unsubstantiated claims. So this, I think, is why the value of the claim has to be assessed right at the beginning and together with the buckets that the losses fall into. So as with delay that we discussed last time, it's always best to get this right to begin with rather than have to rely on experts and lawyers later in the process. So John, maybe you could explain a bit more about the buckets of loss and what can go wrong here.
Yeah, Alex, I think I'd like to do that by example on a job that we were involved with a few years ago, where we were appointed by an EPC contractor to look at his mechanical and piping subcontractors' claim on a fairly large petrochemical complex in the Middle East. Subcontract was typical in this industry of being estimated quantities to be remeasured from AFC drawings that were produced by the EPC contractor. Subcontract price was in the order of $100 million US, and classically it was split into indirects and direct costs on a basis of 40 million to 60 million. And also typical for the industry, there was an allocation of man hours against the quantities in the estimated bills. The original subcontract period was for 24 months, and there was a delay of 6 months on this project. And the EPC contractor had conceded an EOT for 5 months due to the usual classics of late and revised drawings, late materials, late equipment, you know, that everybody knows about, the typical things, and a number of change orders. But the EPC contractor also argued at the time that the subcontractor had contributed to the delay due to a significant amount of rectification of defective work. And it was poor welding and things like that. Not unusual stuff, but it was not a good job. And he'd taken some advice before we got involved, and they'd said that this was running concurrent with the delays caused by the EPC contractor. The LDs on the job were not deducted because there's a 5-month extension of time, and there was already in the contract a 30-day grace period, so LDs weren't an issue. Interestingly, the subcontractor's claim equaled the subcontract price, more or less. And that's the first thing you think, you know, when you've been asked to look at something. Does this sound right? Not really. So then you have a question mark in your mind. What am I really looking at here? But just to give an idea, they'd claimed about 15.5 million for prolongation costs. They'd a loss of productivity claim for 42 million. They'd an acceleration cost of 22 million. They'd overheads and profit of 15 million, and there were some small items that came to 5 or 6 million, something like that. However, except for one paragraph, in fact, I think it was a paragraph that constituted a sentence, referring to remeasurement and change provisions in the contract and extension of time and related cost provisions, this claim didn't attribute any contractual provisions or other means of contractual or legal recovery for anything asserted. We started our analysis, as I would always do in a situation like this, by asking the question, okay, what are we talking about in value terms? And we found that the remeasured quantities had increased by 23 million to 83 million, which is about 38%. And there was all sorts of reasons for that. I won't go into scope changes in the main contract and such like. And obviously the man hours had gone up proportionally to that. We also found that the EPC contractor had ordered several significant changes, which also amounted to about $17.5 million. And again, there was a large labour content for that. So we then looked at the loss of productivity claim, and this was based on a very simple man-hour calculation, which was, this is what's in the bills of quantities, and everybody can see it in terms of the man hours. And these are the man hours we've spent, and therefore we take A from B and we get C, and that's the claim. Very sophisticated. So when we looked at this, we saw no account had been taken of the 38% increase in man hours through the remeasure, or the variations, change orders that had been issued. We also noted that the same values of man hours had been duplicated from the acceleration claim or vice versa, and that taking no account of the defects, the man hours spent on defects. And this was slightly stupid because it was such a mess that the contractor had insisted that the subcontractor provide separate gangs, and they were monitored on a daily basis. So we had an accurate record of everything that had been spent on correcting welding and other problems. The upshot was that in terms of the so-called loss of productivity claim, we could account for more or less all the man hours for anything other than loss of productivity. There just wasn't any. So in reality, the only man hours for which there was any potential recovery was in the acceleration. And in principle, the contractor might have had entitlement to a claim. However, we got one or two problems there because there was no provision for acceleration in the subcontract. There was no way the contractor could request it or insist upon it or anything else. The parties had not entered into an acceleration agreement, which I think is, in these circumstances, is absolutely fundamental. There was no specific instruction from the contractor to accelerate. What it said was, you're behind schedule and fix it. And the subcontract said, okay, basically, and mentioned nothing else until the claim arrived. And he just confirmed, you know, I'm taking measures to try and reduce the delay. It was slightly complicated because there was clearly an entitlement to extension of time, and it was granted ultimately. But when the claim arrived, it was for the for constructive acceleration, which didn't really fly because there wasn't any grounds for it. We then looked at the costs that they'd used for calculating the man hours that was allegedly used in, and all the other resources that were used in valuing the acceleration claim. And these were significantly higher than the corresponding rates in the contract. So there was a little bit of opportunism creeping in there. And basically, we had nothing to work with, so we used the rates in the contract to try and get a fix on a proportion of those man hours, because clearly the subcontractor had been doing something to try and alleviate the delays caused by the contractor, as well as his own delays. So there was a certain amount of apportionment that we had to do. Now, given that we got some concurrent delays, we looked at the prolongation costs to see what that meant. And really, there was, again, an overlap between the resources that they claimed for prolongation with those that they claimed in the acceleration claim. So you'd got management and supervisory work, people and so on, the type of thing that you would put into a prolongation claim as well as an acceleration claim for the additional ones, but they claimed them twice. And they'd also taken the commercial decision that the rates for those were significantly higher than anything else in the contract. So what we were looking at was a claim that it was in itself was self-defeating for a number of reasons. That it was basically overclaimed. It had not looked at the real situation. It had not stepped back to see what the actual value of the job was before looking for losses and other claims. And lastly, they'd added a nice round sum of, I think it was 17.5% for overheads to the amount of the claim. Well, that got a red line through it straight away because it's just not going to fly, no basis. We recommended to the EPC contractor a claim settlement level to be negotiated around 10 million, and that was presented to the subcontractor. He rejected it outright and sued us, and then he lost heavily. So, you know, I think that the lesson from that, and it sticks in my memory because it was quite an interesting case of how not to put a claim together, how to actually, you know, take great care in looking at what you're claiming, why you're claiming it, under the right headings, ensure there isn't any double dipping, make sure that what you're actually valuing at or costing at or assessing damages at, you can justify. And that somebody isn't just going to drive a battleship through it and sink your case out of sight, which is what we did. So I don't know whether that answers your question or not.
I think it's a great way of answering the question. I agree. It's a very good example of how not to make a claim, and it kind of touches on, I think, some of the things we discussed in the first webinar about, you know, make sure the claim is realistic. And you know, it seems like that subcontractor in that case was obviously trying it on, but in not considering the settlement offer that was made, which seems generous in the circumstances. You know, it had no realistic assessment of its own case, and I think that's part of the problem we discussed at the outset, really, isn't it? Which is you have to know the reality of
Yeah.
what you claim. Okay, I'm going to talk quickly about
Sorry, go on.
Yeah, I'm just going to say I'm going to talk quickly about the loss buckets, and then I'll hand back to you, John. I think starting point for assessing the claim really is what sort of claim are you bringing? Is it a claim that's brought under the contract, or is it not? Is it for breach of the contract? I think most construction claims are probably going to be under the contract, because that sets out the remedies that are available and the scope of those remedies. But the amount that can be claimed really depends on the wording of the contract. So if it's a breach of contract claim, then any losses flowing from the breach of contract can be claimed unless they're too remote. Those are the Hadley and Baxendale principles that I mentioned, subject to any limitations or exclusions of liability. So I think you'd always start with your loss buckets, and those loss buckets are our three topics today: value, cost, and damages. And I think if you're looking at value, and John, you'll expand on all of this in a minute anyway, but I think value is essentially change orders and variations. If disruption results from a change order, then that's pretty good for a contractor, generally speaking, because the loss is easily quantifiable because it is derived from the contract rates and prices, and those probably include overheads and profit as well. If it's cost, I think you have to check the contract. There's a question whether that may include overheads. It probably won't include profit unless it's FIDIC style. In certain circumstances it does. And if it's damages for breach of contract, then I think you have to appreciate that those are quite wide, but you have to prove them, and you have to prove them as a result of the breach of contract. So there's things that can't be relevant or might not be relevant when you make that assessment. So John, if you're the contractor, what information are you looking for to justify and assess which losses fall into which buckets?
Well, I think we take them as you've done under value, cost, and damages separately, because I think it varies a little bit in each case. As you mentioned, a value-based claim is probably best in terms of return because you're getting overheads and profit on it based on the unit prices. But that does presume that you haven't underpriced the unit prices in the first place. There's always a caveat in everything. But what it really means is if you're going for value, then it's necessary to identify all the additional and change work. You were talking about change orders, yes. And that includes where rework is being done. I think I have a view that change orders or variation orders are often underpriced by contractors because they don't consider the full implications of the change, what it was for, and when it was instructed relative to the actual status of completion of the work. So if we've got to go back in and do rework, if we're doing work out of sequence, if we're re-entering areas that were originally supposed to be finished, then that's all part of the change and it should be valued as such. So I think stepping back and looking at what is this change, what does it mean, and what are the implications is really quite important. And of course, all that depends on the records that you have available to be able to identify at that time what is actually changed and the circumstances under which that change was implemented. I think that when we look at cost, this actually infers actual expenditure, and often the contract will say that exactly that. Therefore, cost claims need to be based on cost records, and if you haven't got accurate cost records, your cost claim is going to be somewhat limited. And I think those costs, it extends to home office costs for management, project management, engineering, and so on, depending on the actual nature of the claim that you're making. And of course, it will include materials and equipment if you're doing something, on a reimbursable basis somewhere, and saying this has cost me X or Y, then you need the cost of those materials. And we mustn't forget transportation and shipping, expediting, all of those things are part of the cost of doing the work for getting materials, equipment, etc. To the site from wherever you're purchasing the things. And the key to proving cost, of course, is what are the timesheets and allocation sheets, invoices, vouchers, receipts. We need all that information. And surprisingly, it's often difficult to get to that for the actual issue that we're talking about. And overheads, of course, may or may not be acceptable in terms of cost items. Depends what the contract says. Usually, yes, I agree with what you said earlier. If we go to damages, then this, from my point of view, they're sort of close to cost in terms of what can I prove, what do I need to prove, but costs, unlike damages, are unlikely to restore you to the position that you would have been in had the breach not occurred, because the implications of the breach usually go further than simply a cost restoration situation. So you need to look further for damage beyond what you might see at face value as costs. For example, if a breach of contract results in a delay, but the full effects of that delay mean that you are unable to meet other contractual obligations, or that you have to rearrange vendors and subcontractors or other people that you're employing, then probably the effects of that breach are greater than the costs that you first see, and you have to look elsewhere for the implications and consequences of that, so long as, of course, they are directly related to the breach of contract in the first place. I think it's one thing that I've noticed is that a breach of contract argument is usually dreamt up some way after the claim is being mounted, and is usually a bit of an afterthought. I think it's just totally wrong. I mean, you're laughing, but I think it's true though, right?
No, I agree.
And therefore, I think it's really important to recognize what is a breach of contract and how you're going to deal with it, so you can keep the appropriate records, so you can make the appropriate investigations, and so that you can develop a case that's got some legs and that will sustain. So, Alex, what's the typical heads of loss in a disruption claim?
Well, I think the answer to that is that there are probably several, and the list I'm about to go through is by no means exhaustive. You know, it very much depends on the facts and the project and what's happened, etc. So these are the more typical heads of loss that you would usually expect to see. So the first and probably most well known is prolongation costs. So these are essentially on-site and head office overheads that are the result of delay. They're unavoidable costs associated with extension of the contract period, you know, even where the amount of work being carried out hasn't changed. And so they take the form of on-site overheads, which are time-dependent costs which are not part of the finished works. So it's the cost of labor, the cost of utilities, cost of plant, equipment hire, all of these things being on the site longer than the contractor planned them to be. And they're sometimes referred to in the UK as preliminaries, but in essence, they're time-dependent costs that don't become part of the finished works. And then the off-site overheads, we've referred to these already as head office overheads, which they're also known as. These are the costs of the contractor of running the business, essentially. But the delay to the project may mean that the contractor can't divert its on-site overheads to a new project, for example, or the costs of the business might increase, for example, if more staff have to be employed. And I've also seen some creative contract drafting where contractors, and this is not a dig at contractors, try to define the head office as part of the site or part of the working areas in order to claim those overheads as site overheads. And it's pretty sneaky, but I think they don't, you know, think through the other implications of that, such as CDM, but never mind, by the by. I think there's a perception with prolongation costs that they are the financial side of a delay claim, and they inevitably flow from the award of an extension of time, and that's not correct. Time and money claims are separate, as we've said many times over the last few webinars, and they must be claimed separately. So in terms of showing the overhead claim, they generally are one of two ways this is done. It's either by evidence that the actual overheads were incurred, or it's by a percentage uplift which is applied to the increased cost of the project. I think those of you who've joined us for other webinars in this series will know that one of those methods is better than the other. It's always much better to provide the evidence that the overheads were incurred. I only have to think of a case that I was part of where the judge rejected an overheads claim that had been done on a simple percentage uplift, and he said it was a claim made more in hope than expectation, which is not a good position to be in. So which method of demonstrating overheads probably depends on the forum of the dispute as well. I think in court, if a claimant can't show its overheads, can't show evidence that its overheads were incurred, I think there is an adverse inference that could be drawn from that. Whereas I think for something like an adjudication in the UK, you tend to see percentage uplifts being argued for. That's probably the big area of, or the big head of loss. There are other things. Finance charges, for example. If the contractor has borrowed money to finance the project and then is delayed, finance charges could be recoverable. Loss of profits, again, this is, it's sort of tied in with overheads. It's common to calculate lost profits on the basis of a percentage. And again, I think the same question arises, whether that's sufficient as a burden of proof issue. And whether it is or it isn't, I think depends on the circumstances of the claim. I think for larger companies, if there are many projects ongoing at any one time, then a percentage could be sufficient, especially if the company can support that by reference to its accounts, for example. I think if the company is a smaller company, the Walter Lilly and Mackay case, which is notorious in construction circles for many reasons, not only the colourful language used by one of the protagonists. In that case, the number of tendering opportunities that had been lost was comprehensively detailed out on a schedule, and so the court thought that that was sufficient because it was evidence of lost profits. There's a sort of head of loss of general disruption, and I think that's where the contractor incurs costs as a result of inefficient use of plant and labour, or where the plant and the labour differs from its intended use. It's all a very generally disruptive kind of theme, but it doesn't really fall into any of the other heads of loss, and it can arise even where there's no delay. Of course, this is disruption, so you don't have to have delay. The difficulty, I think, with this head of loss is proving that it results from a change order or employer breaches rather than simply factors the contractor was responsible for. So, if the contractor had inefficient working practices, or if the contractor had low bid the tender in the first place, this could be quite difficult to demonstrate as a result of an employer fault. Wasted management time is claimable as a head of loss. That's the cost of employees or senior managers dealing with projects and dealing with it for substantially longer than they planned in the tender. Those costs can be claimed as long as they're not also claimed separately as overheads, so no double dipping, as we mentioned before. And on double dipping, generally it's a no-no. If you claim a single loss under more than one head of loss, or if you put that loss in more than one bucket, then the effect is it will just overinflate the claim and thereby undermine credibility when someone like John points it out, for example. So it's to be avoided. And wasted management time claims will need to show the extent to which the staff have been diverted from their roles, and that the diversion from their role caused disruption to the business, and that can be difficult, but it requires evidence such as timesheets with a suitable explanatory narrative. If you're doing timesheets, it's best to describe precisely what's being done rather than anything that looks a bit more vague. And then finally, a few other things. The costs of collating the claim are claimable. When it comes to legal fees, those are not claimed as damages. Those are subject to cost awards. So in English litigation, the general rule is that the loser pays the winner's costs, although cost recovery is never 100%. It's usually, if you're doing well, 60 to 70% recoverable, and then the rest is unrecoverable. But bear in mind, in other jurisdictions, parties just bear their own costs of any litigation. So in the US, for example, which parties can spend any amount of money they like and do, it's very different. And expert fees are also claimable, but typically those are claimed as damages, unlike legal fees. So John, we've worked out our buckets, we've identified our heads of loss. What do we need to prove our case?
I think you can sum it up in one word: evidence.
Yeah.
And that preferably is in document form. So I'd like to give another example really of what we're talking about. I dealt earlier with the sort of information needed for value, cost and damages. So what I want to say now, it just builds on that. Evidential documentation is required to prove cause, effect, contractual legal compliance and liability. The documentation takes two basic forms. It's either narrative based, in other words, letters, minutes of meetings, emails, diary entries, etc. Or it's numbers based, so program schedules, manpower reports, drawing issues, all those sort of things, progress reports, etc. So anything that's numerically based. And really one supports the other. You'll be writing about those issues in correspondence, minutes of meetings, etc. So you tie them together. So I'd really like to just take that a little further by giving an example of just the other week. I was asked to assess an owner's counterclaim against an EPC contractor. And in this sense, counterclaim claim, we're talking about the same thing when it comes to evidence. It doesn't matter what you call it. One party is asking for money from the other. And this was about a mining project in Southern Africa. And it was an unusual sort of EPC contract because the owner was alleging that it had suffered damage as a result of the contractor's breaches of contract regarding the sizing of a building that is that was constructed by the owner's directly employed contractor, and the sizing and number of items of equipment to be manufactured and installed by the vendors and contractors engaged by the owner directly. So basically, as part of the EPC contract for the other part of the project, the EPC contractor was doing design-only work for one particular building and its contents and components that were for use for other part of the plant, and which the owner was taking care of. So the owner says that compared to the contractor's undertakings at the time of the contract, the owner had to increase the size of the building in order to accommodate the equipment actually specified by the contractor, which was more items and larger ones. As a result, it's had to pay its vendors and subcontractors a lot more money. And that, as a fact, I think is true. They did. The question is, who's liable? So the only documents that were provided for me to have a look at to give this view, and which were supposed to support the owner's counterclaim, were the change orders issued by the owner to its vendors and contractors, and the corresponding invoices that were issued in respect of those change orders. In my view, on the basis of those documents, the owner had not established a case because, first of all, the owner had not identified and documented the EPC contractor's actual breaches of contract. The fact that the building was bigger and the items of equipment were larger and more of them does not necessarily mean there was a breach of contract. So you have to establish the breach in the first place, and he didn't. There is no contemporaneous notice of any breaches, so he didn't actually mention it at the time. We all happily ploughed on regardless. It's only now at the end, when they've seen the size of the bill, that they decided that they think they've got a claim. The owner had not established and documented the increase in the size of the building resulting from the EPC contractor's alleged breaches. So he'd not really tracked that at all until after the event. The owner had not established and documented the changes and the additional equipment supplied and installed by the owner, vendors, in accordance with the change orders and resulting from the EPC contractor's alleged breaches of contract. And as you were talking about just a few minutes ago, there is no explanatory narrative joining the EPC contractor's breaches with the increase in size of the building and the increase in number and size of the pieces of equipment. So there's nothing to explain anything. Yeah. And the owner had not established and documented the connection between the alleged breaches and the damages that the owner has sought. So, you know, I'm in the business of giving bad news, and I did so fairly eloquently. So, Alex, if we're gathering evidence is a problem, is it a good idea for parties to make global claims or total cost claims?
Yeah.
Difficulties.
Yeah, generally speaking, no. And your example earlier on of the petrochemical plant, you know, it's a great example of that type of claim and the problems with it. And you know, typically parties make what are referred to as global claims or total cost claims. They're slightly different, but they're similar in principle, where they can't distinguish between value, cost, and damages, or if the expenditure that's additional can't be segregated. So we're not going to go too far into this in this webinar because it's probably a whole webinar of its own, but suffice to say there are essentially types of claim where, as John said earlier, the principle is A minus B must equal C. Total cost claim, for example, is one that is at the extreme end of that proposition. It makes little or no attempt to prove any causation. So in essence, the contractor is claiming that it's additional costs above the tender costs where, because they're additional, caused by owner-driven events. Now, there's no demonstration there from the contractor of the causal link between the events and the costs incurred. It's sort of throwing all the mud at the wall and seeing if some of it sticks, really. So global claims, although not that extreme, are similar in terms of proposition. So I think in answer to the question, global claims and total cost claims should be avoided. The contractor should try and put forward its claim divided by, you know, the individual complaints or the individual events or the individual breaches of contract, not simply by cost headings that then try to reverse engineer those points. So that begs the question, John, if A minus B equals C type claims are likely to fail, why do parties make them?
I think it's a good question. I mean, first of all, I think if you simply take one number from the other to arrive at the claim, you're not going anywhere close to satisfying the minimum burden of proof requirements. So the claim is destined to fail. I think from what I've observed over many projects, these claims arise under circumstances on projects which are probably best described as opportunistic. And they're made when one party has leverage over the other. And if we typically think about that, you may have a situation with a contractor and a subcontractor or several subcontractors where the contractor is looking for performance from his subcontractors for his own ends to deliver the project to his client and wants the subcontractors to take specific actions. It's usually about schedule recovery and things like that. And the subcontractors just conjure up a whole list of reasons why they're not liable for the delay in the first place without any proof. And then they say, and by the way, what you want us to do is going to cost X. And here's an assessment of where it is. and it usually involves the 3 letters A, B, and C with an equals between. And they put it on the table, and then somebody has to make a decision whether they're going to pay or not. I think the problem is that a claim like that is only sustainable as long as the circumstances of leverage exist, and as soon as that expires, so does the claim.
Yeah.
Now, often there's good reasons why this happens. You know, everybody's under time pressure and all these sort of things, but really, it's also one of the when the whole thing fails and there is a delay, etc., then the recrimination starts, and then that's when you start to have, you know, the real problems. So even though it may seem a good idea at the time, dealing with those claims on that basis is not, particularly if you run the risk of it ultimately ending in dispute. And so I would strongly advise against it. I agree with you. These claims are best avoided, and it's much better to try and particularize things. So that's my view on it.
Yeah, thanks, John. I think the only thing I'd probably add is that claims like that, I think sometimes they have a tendency to snowball in their effect, because they, you know, the reasons why they arise in the first place are temporary, and, you know, as you say, they can disappear if, you know, if the leverage disappears. But I think they can become sort of ego driven and, you know, personal crusades on the part of one person in particular, who, you know, commits to a position perhaps unadvisedly, and is, you know, justifying that decision to superiors and all these sorts of things. And so you have this snowball effect where a claim, if you'd analyzed it properly to begin with, or assessed the value of it properly to begin with, more specifically, probably should never have been a claim. You kind of create this thing that takes on a life of its own, and, you know, you have this big snowball. But I think when you get into the arbitration or the litigation phase, you find the snowball melts pretty quick, and, you know, it leaves very little behind of actual fact evidence, you know. And that's an uncomfortable thing, because then, of course, you know, all those decisions made about pursuing this to begin with turn out to be, you know, based on nothing really, which is not good. So we're getting towards the end of our time. I mean, as ever, if anything in this webinar made you think of any questions or any issues that you'd like to discuss, then do get in touch with us, talk to me or talk to John about it. We mentioned last time that we will put together a pack of information that we think you might find useful based on the whole series of webinars. So that's something we'll do after the 5th and final webinar in October. Again, if you're interested in that, as some people already are, do send us an email. We'll be happy to share that. And I'm also going to take the opportunity now just to preview what we are going to do next. I mean, as you'll have seen, in particular, this topic, the subject of value, cost and damages, is substantial, and we've really just skimmed the surface in this webinar. So John and I are planning some further webinars on this particular subject, and this webinar series on the psychology of claims has been very popular. We regularly have over 100 registrations for each session, which is great. So by virtue of popular demand, we're planning a larger webinar next time, probably in 2 parts, and each part will be around the 3-hour mark. And we're going to build on what we've been doing in these 5 sessions, really. So part 1, we'll look at time and money claims in more detail, and we'll base those on a working case study. And then in part 2, we're going to look at factual witness evidence, and specifically in relation to giving evidence on scheduled delay or cost claims. And we will hopefully have a senior barrister available who will be on hand to conduct a virtual cross-examination of some of our lucky participants. So if you think you might be in a position where you may be subject to cross-examination, then this will be a great chance to experience it in a safe setting rather than, you know, within the courtroom. So I think that could be quite entertaining. So if that, you know, tickles your fancy, then that's what we're planning to do next. So we're going to have about 30 places available for this, and we will charge 95 euros per person per event. So unlike the free series of webinars that we've been doing, we won't make this publicly available. This will be a sort of more intense and more in-depth couple of sessions on those specific things. So if you'd like further details on that, let us know. And we'll give some more information after the 5th and final webinar next time. And that final webinar is going to be on the topic of alternative dispute resolution, or ADR. So we're going to try and bring things full circle from the beginning of claims through to delay and money issues. And we'll be doing that on the 8th of October at 12 noon UK time. And we'll be discussing when is ADR necessary, how can it be used effectively, and what is needed to achieve successful outcomes. So we hope we will see you again next time. Thank you very much.
All the best. Thank you. Bye.
Thank you.